So good evening, afternoon, morning, everyone, depending on where you are on the planet. Welcome to the Cambridge Arbitration Society, CuArb, and the Lauterbach Center for International Law lecture series. We are happy to be back again this term with our first lecture on the hot topic of third-party funding. Our lecture today will be on looking at the past and projecting the future of the third-party funding practices and third-party funding as a mechanism to fund dispute. Before we start our lecture, I would like to welcome our speakers today, Lewis Young and Ian McKenny. So thank you so much for joining us today. And we look forward to hearing more about third-party funding in a bit. So Lewis is a co-founder of Augusta, the UK largest litigation funder by case volume, and oversees the orientation team. He has extensive experience in investment banking, fund management, company startup, and restructuring arenas. Prior to founding Augusta, Lewis was CEO of another third-party funding or third-party litigation fund, as well as a COO of Normandy Capital Management and MD of a number of international and Australian businesses, including Australian Gold Holdings, Colonial Building Company, and Steelview. Lewis also spent 17 years working in Asia and Africa, where he established and successfully sold 2 businesses there. Lewis is listed as a notable practitioner in Chambers and Partners, and is included in the 2020 Global 100 Leader in Legal Finance Guide. Lewis holds an MBA and an LLB from Bond University. Welcome, Lewis.
Thank you.
Ian is a director and a co-founder of Profile Investment and heads its legal analysis division. Ian spent his formative years as a disputes lawyer with Freshfields, and subsequently Latham in London and Paris. Prior to founding Profile Investment in 2018, Ian was general counsel of dispute and subsequently managing director at Fenn Capital. Ian's specialisms as a lawyer include international commercial and investment treaty arbitration across various sectors, including construction, technology, general commercial, corporate, and finance. In addition to being a qualified UK solicitor and registered foreign lawyer in the Paris Bar, Ian is recognized thought leader for third-party funding in Who's Who Legal. In Chambers and Partners, Profile Investment is ranked among the 6 leading litigation finances globally for international arbitration. So welcome, Ian.
Thank you very much.
So thank you for joining us again today. And so we'll start with Lewis to provide a sort of financial background to third-party funding, and then we'll be moving to Ian to provide a more of a legal background to third-party funding. So the floor is yours, Lewis.
Thank you very much. And welcome, everybody. And it's a pleasure to be here. It's quite strange. I mean, I'm talking to Ibrahim and Ian here, and I can't see the rest of the audience, which is somewhat disconcerting. But I'm just gonna take it for granted that there is somebody there that we are talking to, and I'm just not going to be boring these 2 guys. But starting off, Ian and I got together and said, what's the best way to deliver something that's perhaps got a little bit of real life value and real life practicality for people that are, which I think is fabulous, which people who are actually studying litigation funding now or interested in litigation funding back in the colleges and the education system. And I'm going to spend a very short time sort of looking back on my sort of reflections on litigation funding and where it's come from and that. I was telling Ian here that I had the enjoyment to actually read an article that he wrote today on the advent or the genesis of litigation funding. It is very good, and I'll let you plug that on later, Ian, because it is well worth a read. But look, generally, litigation funding, and this is from my knowledge of it, I go back to what took place in Australia, although my involvement with litigation funding started here in the UK. And I'll give just a little potted history as to how we got going, because at the time I was working in Vietnam, and somebody asked me to come and look at this asset class called litigation funding, and which I had not heard anything of, and so started looking into it. I came across to London for an interview with the people that were already involved in it, and it was quite a fledgling industry back then. I think it was about 2012, and long story short, they said, I think you're the sort of person we want to get, that can help us set up this business. I've got my background is more it's entrepreneurial, but it's also I like getting things done. It's, I can take a concept and then develop something around it. Litigation funding at that point was quite an embryonic industry, if you call it an industry now. You did have some significant players that already started. I think Burford was already underway. You had Bannon Capital were there, and all names you're probably quite familiar with. I think I'm trying to think of. I think Colonius was going, but anyway, I won't go into those full details. But had a look at it and like what I saw, and interesting enough, I saw a lot of similarities in relation to project management. If you had to set up one of these businesses, there was a lot of things that took place in other businesses I've been involved in. You could transport into the industry or import into the industry and build it around, and that everything goes from the underwriting of an investment, how you treat your customer. In many instances, your customers are the lawyers that you're dealing with, and basically this is the customer service business. And so, long story short, I ended up shifting to London in around about 2012. It was. I had my first foray with a litigation funder here, and then we set out to start on our own. And we came up with a concept because at the first litigation fund I was with, there were quite large, lumpy investments that were being made on a per case basis. And you end up with a lumpiness in your portfolio, and one loss is, I used to liken it to the old Monty Python movie where the Black Knight's fighting in the forest and he takes a flesh wound, but it happens to be his arm cut off. And that's very similar when you're in those very large investments. And so we just said, okay, there must be a better way to do this. And we started looking at smaller cases. And there was a strong belief within the general market, the smaller cases couldn't be funded because there just wasn't enough headroom in them. And long story short, we went out and did a lot of market research. We got about results of about 500 cases. And the interesting part was when we went searching for this data to be able to actually model a business model on, much of the information that we were looking for from a finance perspective was unavailable. You could go to a law firm and they would tell you to the last penny what their senior associates had earned for the last 2 years. But if you asked them how many actual cases they had run, how many they'd won, what was the original budgets that you started off with, what were the budgets overruns, was there ATE insurance? And I'm assuming that everybody here understands ATE insurance, the insuring against adverse costs. Many of those questions they just didn't answer. And so it was you were trying to build a model for a business around an industry that didn't measure the same metrics that we needed. We took those 500 cases, we put them with the results and everything, and we would put them into a Monte Carlo analysis, and we would run multiple times the Monte Carlo analysis. And it turned out that, in fact, there were some interesting things. Claimant run cases, 92.5% were settled before they actually ever went to trial. Of those other 7.5%, it was around about 60% were claimants successful, and 40% went to the defendant. So all of that there, we took in and took a statistical analysis to the investors that we then spoke to, and which resonated well with them. And we raised our first money in around about 2013, it was, and we made our first investments in 2014, and it was 4 or 5 of us operating out of a very small office. And then looking back, it's now coming into it. We were quite regimented in the way we diligenced cases, and it was hard. Like when we first started off, quite an interesting part is when we first started off, it was like every lawyer leant down into the filing cabinet down beside themselves, and they took out every case that was an old, ragged, dead-looking case that they had money on the clock with, and they turned up to us and put it on our desk and said, "I'd like funding for this." We probably spent the first 6 months of looking at cases, and we probably had a rejection rate of around about 98.5%, because we were sorting through a lot of the chaff. In the first year, interesting enough, we probably made around about 30 or 40 investments, and that was us. We got going, and then the business has grown from that point on. And we've had the fortune to be able to watch the growth, watch the maturity of the industry, to watch the acceptance of it as an industry, and to watch it sort itself out. And the things that I've noticed in relation to looking back at what I've seen is every funder starts off with a track record of 100%. So, everybody has got a 100% success rate until you actually start getting the resolutions. And it's not really until you've actually been running for a reasonable amount of time. And by that, given the nature of the investments that you make, a lot of these cases will run 3, 4, 5 years. Your long run average, which is what really speaks to a funder and to itself, then starts to play out. And I think we've plateaued out. And if I had to say what happens with us, if in an elevator pitch, we win 2 out of 3, and that's probably about it. And so that there's significant vagaries within the information that you have at the outset of making investment into a case. And that probably leads to the second point, which is diligence. And we soon learned that it was just as hard to determine whether a small case was going to win as it is to determine whether a large case is going to win. And yet the problem with in between the small cases and the large cases is that you don't have much headroom in the damages. So you have to underwrite very, 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 very rigidly. And we took that whole ethos with us as we've grown our amount of funds under management. So as you grow funds under management, you can do larger cases, and those larger cases tend to have more headroom within the damages. So it actually gets easier as you move into that part of the case, the case universe. I think another interesting thing that I would bring out of that is the beneficiaries. Like who are the people that actually benefit from the litigation funding, and when we're out there promoting litigation funding, you're always promoting it to the benefit of the claimant, and that's the way it should be. But if I had to take a cynical view and look back on it, I think that the one parties that do benefit in this is the lawyers. The lawyers are getting the fees, and if there's been a part of the industry that has been that has benefited greatly from this, it's the legal profession. And it's not because there's funders out there that will just throw money at any case. It's just the fact that there's many very good cases that never got to the courts because of the simple costs of actually running those cases. And those cases now are finding their way through. And it's not just the claimant lawyers that benefit from it. It's the defendant lawyers. There's many defendant lawyers now who are as much a champion of litigation funding as what the claimant lawyers are. And I think that probably brings into my other observation of what I've seen in the last 10 years of litigation funding, is it used to be that when we went out to market ourselves, and the principal form of marketing is through law firms and that, in many instances you spent the first 40 minutes of a 1-hour meeting educating a lawyer about what litigation funding was. But now when you walk in the door, people know, that like, I suppose it's one of the traits of a lawyer, that they learn very quick. And the other thing is another trait is that most lawyers don't like to not be the smartest person in the room. So by the time we get in there now, lawyers understand litigation funding. I think there's still a bit of a journey to go in relation to the commercial aspect of that, because many lawyers think I have a good case and it stops there, because generally if they win the case, they've been paid their fees. They generally don't have to then worry about actually getting money from the other side. And that's very much a key focus in what it is that we do. And I think the last observation I would make in looking back would be mistakes. We've made mistakes, and I can tell you it's a very unforgiving industry. You know, there is, if you make the mistake, whether it's at the diligence phase, whether it's, you know, we had an opportunity to get out here, but we didn't take it or whatever. If it goes against you, it goes against you. It's a binary outcome, and those things hurt. You know, it's quite amazing. I had we have an office in Canada, a good guy out there, and you know, it's a young office. We've got 4 or 5 people out there, and they had a case which they thought was, you know, this is a good one for us to invest in. And the other day, the decision came down. The case is lost, and the emotional buy-in from the people that actually underwrote the case and have then been stewarding it through. And don't forget, if the case runs for 2 or 3 years, you're in direct contact with the lawyer all the time. That relationship is building up, and everybody shares the disappointment. And you know, it's just, there's a lot more than just losing money. It's losing that. And so look, that's my observations looking into the past. I think it's an industry. It's developing. I think, well, possibly one of the last things I'll add is it's very interesting now to see the people that are moving into it. You know, the mere fact that I'm sitting here now and talking to you as a university, in Cambridge University, and that you've got the interest in it and you want knowledge of the industry, that just didn't exist 6 or 8 years ago. And I think it's great that people that you're seeing coming into it is you're seeing professional investment people now coming into it. And what you're starting to see is, when we built the business, when we first started our business, our primary underwriters of cases and that were lawyers. And now that underwriting still has to take place, but it's less of the focal point, and more of the focal point is now on around the economics and that. So it's almost like the legal aspect of it is becoming a you know, it's a necessary piece of the puzzle, but it's not the only piece of the puzzle now. And so I think that's it. You know, we are prodigious spenders for legal spend. Like, I think around about 32% of any investment that we make goes to paying lawyers' fees. It's around about 28% goes into barristers' fees. There's a big chunk of it goes into adverse cost insurance, because that's part of the undertaking that we make to the claimant, that it's not there for, you know, they're not going to suffer additional risk thereafter. And then there's a smattering of other fund or uses of the cash. So that there is where I've seen the market come from and where it's developing. I think it's becoming more professional. I think it's growing as an industry. There's no doubt that the amount of capital coming in is increasing. And I think, although a danger is that there is so much capital out there that is looking for a home for uncorrelated returns, etc., alternate returns, is the danger is that the lessons that we've learned over 8 to 10 years, you can't just buy those lessons. And that means people will come in and perhaps take up investments that otherwise that we scratch our heads and just say, I can't understand why they'd be taking that up. But look, that's my thoughts on what I've seen in the past. And by all means, if there's any questions out there, put your hands up on that. And otherwise, I'm happy to take some questions at the end. But looking forward, what do I see looking forward? I think the investment quality that is now coming to us from lawyers is increasing, and it's a much greater quality. And that's because it's taken that 8 to 10 years for people to actually start learning what it is that the funders are looking for. And so that's happening. I think more claimants are becoming more comfortable with litigation funding as a whole, and they're also becoming more comfortable with foregoing part of the pie to be able to reduce the risk. And certainly we saw a massive uptick in that across the recent pandemic period that we've had, and I think more of that will continue. You know, people have got better uses for their cash within their businesses. And I think also one of the big things I've noticed is the quality of the law firms that are now bringing the claims to us. If you went back 5 or 6 years ago, I remember walking into a Magic Circle law firm and talking to the partner about litigation funding, and his response was, if we've got a client that needs litigation funding, then they're probably not the sort of client that we should be dealing with. And that is changing, and the lawyers are offering a broader service and a broader offering to their clients, because they know that that's what their clients demand. Clients are sophisticated people, and they understand the value of cash. So there's one thing: investment quality is increasing, and those parties that are bringing to us are increasing. Competition, as a market matures, you do expect to see more competition. I think law firms are starting to internalize a funding offering themselves, and I think a lot of people here would have read about Mishcon and what they're doing, and there's other funders, there's other law firms out there that have done it. It's an interesting one because we were talking just before we opened it up to everybody here, is just conflict of interest within what it is we do is front and center. You have to be aware of it at every step you take, and I think that there possibly brings more conflict within the whole transaction of providing funding for a claimant. How do you determine which claimants that you as a law firm provide your funding to? And does it send a message to a claimant that if you're not providing them funding, that their claim is not as good as what they thought it might be? All of these interesting things will be teased out. And look, smart people will find answers to this, and smart people will find ways to separate them. So I think that's one. Competition. You're seeing competition from the insurance sector. The insurance sector is a big old beast. It moves slowly, but when it does move, they can come up with some very, very interesting alternatives, and it's almost like it's almost like a shadow play. Insurance is almost diametrically opposed to what we are, whereas we put our cash out up front, and then we wait all the way to the end for a win, and then we get a return back. They put nothing out front. They get some cash up front from us, and then they wait for a loss. And if that happens, they have to. So it's quite interesting. And I think there's going to be a lot more interaction between the insurance industry and funders themselves, and also law firms. Because it's a deep industry, the insurance industry. We see competition from hedge funds. Smarter hedge funds are getting involved in it. I think one of the ones that have really taken the sort of bull by the horns is Fortress Capital, and interestingly enough, they became a funder of funders, and so they've had insight into it's. When we look at it, like on average, we're probably seeing, okay, so we're 8 or 9 years into it now, and we're just coming up to 10,000 opportunities that have come in front of us. And so we as a company see a lot of opportunities. Now, take somebody like Fortress. They've seen 5 companies like us with that sort of, and by the way, we don't take money off Fortress, but they've seen 5 companies like us and had the insight into how that operates. And I think it's a very clever way they went about it. And I think the last one is that you've got new funders coming into the market all the time, and they find opportunities where they see less competition. And for instance, the funding of consumer litigation and law firm lending, and there's a myriad of different ways. I think this whole litigation funding's come about primarily because the whole legal sector has been underbanked for so long, and people are just waking up to it that is that's there to be, I was going to say, taken advantage of. It's not that. It's just it's an area to be serviced to. The other one that so the other things that I see in the future is risk management. I think you're going to see funders like ourselves, as the cases become more complex and larger and need more cash. It just becomes difficult to be able to take all that risk into your own book, and so you'll start to see a securitization, very similar to what banks do now. Like somebody will go out there and fund a 40 million pound mapper, but they will break that up amongst peers, and so people would diversify risk like that. A big one that you could possibly have a whole lecture on is regulation and institutionalization, and it will be a very interesting conversation, because I think as an established player, you welcome regulation because regulation becomes a barrier to entry. But I think regulation is being promoted for the wrong reasons. I think the original reason of providing access to justice to those people who don't have the wherewithal to be able to take cases forward is still a very, very potent reason as to why this industry should be allowed to flourish. And but you tend to find that much of the call for regulation or the rattling of sabers and that is being done by the people who are most at risk to it, and the most at risk are those who transgress all the time. And you know, it's the big organizations. I mean, one of the fiercest opponents to litigation funding is the American Chamber of Commerce, because they are a representative body of the entities that are actually getting cases brought against them. So look, regulation's happening, institutionalization's happening. You're seeing secondary markets open up for cases. Yeah, a litigation funder will come in and take out the initial risk, and then bring in a sell a piece of that particular claim, and that then puts a mark to value, and that party buying the claim is prepared to pay a premium because they're actually getting in, because some of the early risk is being taken out of it. You're seeing investors who are forever looking for homes or forever looking for investments that are not correlated to the general markets. And this is, you're probably well aware of this, but you know, large pension funds and everything like that. If it took us 6 to 8 years to, I'm not going to say educate, but it took us 6 to 8 years to get our message across to the law firms in general, it'll probably take 8 to 12 years to get the message across to LPs like pension funds and endowments and that. But they're now starting to say, we do want to be involved in it. We realize it's not, you know, it's not ambulance chasing or anything like that. It is a valued product within the whole fabric of what the legal market is. I'm not going to take too much. I've probably got another 5 minutes or so, but I think one of the most interesting things is also the people that are coming in, you know, is highly educated people that are coming into this, people with very, very good intent. And that's then leading to some very interesting products. I think there's a lot of talk about ESG, and I just thought, okay, ESG, great, you know, let's go do a fund and raise some money, and we'll go after just, you know, go after BHP who's had a mine spill and stuff like that. But what we're finding, and it's far more complex, and the people who are actually promoting this are people who litigation funding is going to be used as a device to actually change behavior rather than just monetary gain. And that's what we're seeing. And I had a very interesting conversation with a group in Copenhagen, and you know, these are people that have been involved in ESG related spheres for the last 25 years. And they said many of the investors that are looking now to come in and support an ESG related litigation fund, they're not just looking for monetary outcome, they're looking to change behaviors of the groups that they're going up against. And they will actually forego monetary outcome as long as they can get a change in that behavior. And it may well be that, just trying to use an example here, you know, rather than having mines in Africa have tailings dams that are, or weak tailings dams, or people exposed to cyanide that's used for processing of gold and copper and that, if you can effect a change within the company, then they're prepared to give up part of the damages to make sure that the company goes forward on that. So I think it's starting to come of its own. And I think all of those things that we've just discussed here as far as product and that is only going to get better for it. And so, you know, I'm quite envious of the fact that, like, I had a midlife crisis and did a law degree. And I would have loved to have sat in front of somebody if they could tell me it's something about the litigation funding industry, because I think it's an enormous opportunity for those in the legal profession. And if I had to give one bit of advice, I'd say, like, learn how to operate an Excel spreadsheet, because so much of it is driven there. Know your law, but also learn how to operate an Excel spreadsheet, because at the end of the day, it is an investment class. So with that, I will draw to a close. I don't think I've drawn breath, so I do apologize.
Thank you. Thank you so much, Lewis. If there are any questions, we can receive them now for Lewis, or we can wait until the end. So if there are any questions, we can give them now. Otherwise, we'll wait until the end. Okay, so shall we move to Ian, the legal perspective?
Sure. Look, first I wanted to thank Lewis. He covered an awful lot of stuff that, frankly, I get to deal with day in, day out. We've both been living this for the best part. Well, certainly, I've been living this for well over a decade, and Lewis has been doing so even longer than I have. And the practical insights of this industry are something to be noted. Because of course, third-party funding, as we know, is and seems set to continue to be a steady part of the litigation landscape. So what I thought I would do is provide you with a little framework, as it were. When I think about third-party funding and the evolution of it, where it came from, where it is today, and where it's going, I initially did so in its full context about 3 years ago for the law review series, where I wrote a chapter called The Evolution of the Third-Party Funder. And in so doing, it did allow me time to reflect upon developments in case law, different jurisdictions and the like. And I put together a table, which then formed the basis of the entire chapter. And I thought it might be helpful if I just went through some of the clear kind of paradigm shifts that I've seen across the industry in the time that I've been doing this. Now, what I would start with is something that I'd like to refer to as the pre-industry age, right? There was a time before third-party funding became an industry of and in itself, but it still kind of existed in almost a primordial fashion. There were funding houses and investment houses that were investing in litigation financing, but it was done very much on an ad hoc basis. And this was long before I had looked at third-party funding. I was at best a very junior lawyer in a law firm, completely oblivious to the wonders and splendors of litigation financing. This age was typified mostly not by lawyers, but by investors, financiers, brokers, insurers, who are all looking at, who could see the opportunities and wanted to present them at a time where there wasn't a great deal of money that was being pumped into this industry, or because it was not an industry as of that time. And of course, this would have probably been, I'd say, late 90s to the early 2000s. That's more or less what we're looking at. So litigation financing existed. The terms were messy. It was not clear necessarily even in some jurisdictions whether or not it was a breach of champerty and maintenance laws, which continue in certain jurisdictions to this day. There were certainly no regulations or oversight, as you'll see in countries like Singapore now, with the regulations in respect of third-party funding, which are obviously have been mirrored in Hong Kong and are developing in the UAE. This was way before that, and it wasn't really even a thought as to whether or not this was an industry that needed oversight and regulation. So what takes a pre-industry ad hoc investment opportunity and turns it into an industry? Well, as a lawyer, I will say that it needs frameworks and guidelines and typically case law. And for that point, when you get into the kind of 2005 to 2010 period in this relatively young industry, you saw the development of, I would say, 3 seminal cases. And this is really what kind of transformed and developed the industry. And I'll tell you those cases in a second, but what do I mean? What do I mean by these cases kind of developed the industry? Well, without these cases, it wasn't really clear necessarily what was permitted, what was not permitted, who was going to be liable for what. And in so doing, these cases provided a framework which enabled those ad hoc players in the pre-industry age to actually form actual real businesses with the sole intent of furthering litigation financing. And the first of those is a case which will be known to many of your students who have looked into this. It is now the infamous Arkin versus Borchard Lines case. And this was a case in the United Kingdom specifically, which established the extent to which a third-party funder, litigation financer, as it may be, could be held liable in the event that a case was not successful. Now, why is that important? Well, it's important because up until that point, it wasn't quite clear, especially in respect of the champerty maintenance laws, which, in relative terms, had only really been repealed in the 1950s in the United Kingdom. It wasn't really clear whether or not the litigation financiers were stepping over that line, right? And so this actually was trumpeted at the time as a death knell for the litigation financing. But as it turned out, it was actually very much the opposite. It had provided the anchor upon which people could actually start to build a framework, and they could see the extent to which litigation financing was not only embedded in the legal landscape, but also the extent to which certain lawyers who may have been afraid of taking it because of uncertainty. There's nothing lawyers hate more than uncertainty, not being terribly, not being creatures that have a great appetite for risk. And so these types of clarities provided that certainty for law firms to be able to transition from this is an opportunity for somebody to pay for a case on a one-off basis to this is something that we need to really seriously start looking at because it could be a tremendous source for work. The courts got more comfortable with it because they made a declaration that this thing is not crossing any lines, and as such, despite the fact that we were talking about a case that established liability for litigation financers, it provided litigation financers with clarity and a means by which they can address their own liability. Now, what do I mean by that? Very simply this. Lewis mentioned it earlier. It's something called ATE insurance, which is typically adverse cost insurance, which some of you will or won't be familiar with. And this adverse cost insurance had existed in England long before. England was one of the first countries to really push it forward. And it basically acts as a form of guarantee in the event that an unsuccessful claim is pursued against a respondent or defendant. And that defendant is entitled to costs. The rule being in the UK, as it is for many common law jurisdictions, that costs follow the event. Now, this was particularly helpful because it allowed the ruling on Arkin by the litigation finance industry to establish and see a means of securing and mitigating that risk. So in addition to providing clarity and certainty as to how this investment opportunity would develop and work within the legal landscape, it also allowed them a way of mitigating that risk. So the next case that I would say is certainly worth looking at in this kind of, early industry age, that 2005 to 2010, and even that kind of post-industry age, those early times, which I would say is probably 2010 to 2017, in and around there, is Excalibur. Now this is the Excalibur Ventures versus Texas Keystone, I believe, which again, a very interesting case of and in itself. If you haven't read it, I encourage you to do so, not least of which because, again, like Arkin, it was held up as a death knell by certain people for the third-party funding and litigation financing industry, when in actual fact, it ended up having the exact opposite effect. Again, Excalibur talked about the extent to which third-party funders should be held liable for backing an unsuccessful claim. Now, in this particular case, the Wempens, two brothers who had certain experience with a post-war Iraq, had gone over in order to try and secure various oil field drilling rights for certain majors. And they did so under an introductory agreement. Now, this introductory agreement was largely bogus, to be completely frank. It was opportunistic, and a lot of the oil majors said, well, these introductions that you're making, we already have and had for many, many years. The case was dreadful in terms of its merits. But here's the thing. The case was being run by Clifford Chance, and Clifford Chance lawyer, who shall remain nameless for the time being, but it is easy for anybody to go and find, had written a legal opinion to the litigation financiers explaining what were the prospects of success. And they put the prospects of success at 80%. Now, as Lewis, I'm sure, will confirm, and myself, I have never seen a serious legal opinion which would ever give a claimant a prospect of success anywhere near 80%. And so immediately there was alarm bells kind of ringing, as it were. But this case had that, and as a consequence, a small pool of relatively inexperienced litigation financiers put monies together in order to support it, having done very little in terms of merits review or analysis. And why is that relevant and important? Well, it's an evolution from the Arkin case for this reason. The distinction made by the judge, who very quickly saw through the fact that this case had very poor merits, was that there is a distinction between and an obligation for litigation financiers to do their research. It is not sufficient to adopt a legal opinion not written for you, a legal opinion written for the claimant, so there is no duty owed, and do no further due diligence or analysis yourself, right? And then make the investment, because if you do, you could be ultimately investing in a claim which is unmeritorious, which would cause undue burden to a respondent, and quite rightly should result in some payments being made. Now, why was this case important for third-party funders? Because, again, it established some rules about the degree to which litigation financiers should be conducting themselves. Right? It is about driving a merits-based analysis. The litigation financiers are obligated to do their analysis, and those who don't may be held liable. And it was a split, right? So as opposed to Arkin, where the question mark was, is this now automatic? if your case loses and it's got financing, do you automatically get to sue the litigation financer behind it? Or is there a real question mark as to whether or not the litigation financer fulfilled their obligations and duties? And I would argue that this is the transition from being an industry towards a profession. And this is also happens to be where litigation finances started going to all of the big large law firms and recruiting top lawyers because they understood what the impact was. And again, so instead of Excalibur like Arkin, instead of it scaring off potential players and investors in this area, all it did was provide a more solid foundation and groundwork for them to say, well, we have further clarity as to what our rights, our obligations are, and how, and a real pathway as to how we can mitigate these risks, right? Bring in more lawyers, right? Treat this like a serious thing. This isn't something that should be looked at devoid of, legal assessment, where the duty for that legal assessment is actually owed to the one making the investment. And as a consequence, what you saw was this development of this self-proclaimed profession of legal financiers, as it were. After that, what we saw in this next kind of paradigm shift in this kind of more post-industry world is a case that I want to talk a little bit about, and again, something worth knowing about if you're looking at this area in detail from a legal perspective, is the Esser Oilfields Services versus Norcott rig management company. This was a seminal case, again, an English case, which provided yet further clarity, potentially, for litigation financiers. In this case, and I won't go through the facts, if you want to take a look at those, I'm conscious of time, please feel free to look that up yourselves. I make various references to it in the chapter that was published earlier this year. But the nut of it is simply this. Question marks were raised over the extent to which the cost of litigation financing could be recovered in the event of success. That is important for a variety of reasons. Costs of litigation financing have swung dramatically over the years, from anything from 80% of the damages in that pre-industry age to a kind of a 3 times multiple to the greater of 3 times or 30% of the damages. And more recently, I think as the industry has developed, you see more moderate terms. But that's inevitable with the kind of investment that you see going into this industry and this profession. Norcott basically awarded to the claimant under the 1996 Arbitration Act costs that, owing to, let's say, a certain ambiguity, and I believe it's section 14, Abraham can probably correct me if I'm wrong, of the 1996 Arbitration Act, allowed a respondent or a claimant who has received a cost order to claim for costs that go necessarily beyond the direct legal costs. And so the court, in hearing submissions on this point, which is where Norcott had, or rather Esser had asked for the costs of not only the cost of pursuing the claim, but also the cost of financing that goes towards that claim. The court took into consideration some interesting factors. Factor 1 was the general conduct of the respondent. Now, in this case, and the court were careful not to, to narrowly define the circumstances at this point for when litigation financing can be included into costs. they thought that the respondents' conduct had been a deployment of various egregious strategies in order to delay and disrupt and prevent the case from pursuing. They were not engaging in the dispute process in good faith, and as a consequence, such egregious conduct was considered by the court to be a supporting ground for why litigation costs or additional costs might be considered. The second part of that was to weigh up what was litigation financing, right? Was this a loan? Was it some form of insurance? Or was it a real cost? And as a consequence, this is where they got into the nature of third-party funding, something that Lewis described very succinctly at the beginning of his talk. This is not a form of insurance. This is non-recourse financing, whereby the monies that are invested can be lost. It wasn't, as a certain well-known arbitrator had tried to define it, as heads we win, tails you lose. It was very much a risk that was assumed and a cost as a consequence that was payable. And so for this purpose, the court actually considered that those costs were recoverable for those two primary reasons. So those are the kind of the three cases that I direct you towards looking at in the development of third-party funding in an evolutionary sense. Kind of looking forwards, one of the things that I wanted to talk about is something that I've been following with a great deal of interest for a number of years now, which seems to be two competing models of third-party funding. You've got a model which I would say is more kind of a derivative from financial markets, where pricing the risk becomes kind of a standard way of assessing value and mitigating potential losses. And what does that mean in terms of litigation and litigation financing? Well, a price the risk strategy would suggest that even cases as bad as Excalibur could be financed, providing that the terms were sufficiently high. That's what I'd see in its kind of most extreme form, right? A pricing the risk strategy is potentially difficult and dangerous, I would argue, because it tends to treat the litigation system and the dispute system like the financial system. But the biggest problem with that, of course, is that the litigation system has never been set up to operate like the finance system. There are many issues at stake here, but I would say that the most distinguishing feature is simply this. When you look at a finance system where you're adopting a price the risk mentality, you are looking at the value, the cost, the monies that are to be made and to be returned. And I would argue that litigation financiers, as much as they need to keep these models in their mind, also cannot lose sight of the fact that litigations, arbitrations are primarily about the dispensation of justice, first and foremost. The compensation of loss is part of that. That's what flows from it. But it is the dispensation of justice which is the paramount functioning purpose of most legal systems. Now, if you were to adapt a price the risk approach and not keep in mind the importance of the dispensation of justice argument, then you can find yourself in situations where a multitude of claims that perhaps do not have terribly strong merits could find themselves in front of a court or an arbitral tribunal. And that is particularly difficult, I would say, mostly where states are involved, And now whether or not that's in investment treaty arbitration, so they are direct party to the dispute, or if they're the ones that are funding the litigation system in national domestic litigation, that becomes a bit of an issue, because it all becomes down to a question of taxpayers' money, right? And at that point, whether or not a claim is meritorious and not meritorious is very, very important. It cannot simply be about pricing the risk, because we're talking about the public monies being used either in the administration or the defense of claims. And as a consequence, these types of cases can end up drawing negative attention in terms of oversight, regulation, and similar types of impacts. Put very simply, if third-party funding is seen as a access to justice tool, if it is seen as something that can facilitate both lawyers' access to clients and clients' access to the lawyers, it will unlikely draw adverse regulations, oversight, complaints, and the like. And if third-party funding is seen as much more of a scattergun approach, pricing the risk, not necessarily looking at the merits, as the case law has indicated to this date, then it does risk drawing more severe and negative regulations and oversight. And this is kind of clear in a variety of jurisdictions even to this day, right? In Singapore and Hong Kong, as I said, they put out the regulations in respect of third-party funding. They're doing similar things in the UAE, certainly in Dubai. They're considering it. If they haven't actually put it out already, Australia, they're looking at putting out licensing. In certain countries, like in Canada, in order to have third-party funding apply, you need direct consent from the court. And all of this is in reaction to, I think, a cautious approach by a variety of legislators and regulators as to the approach that litigation financing has had towards the litigation landscape. I will end very quickly just on a slightly more positive note. The more positive note on this is that I'd mentioned before that there are two competing models, and I talked about the price, the risk approach. Now I want to talk a little bit about kind of the merits-driven approach. And that merits-driven approach is very much kind of not losing sight of the fact that disputes are about the dispensation of justice. And as a consequence, funders doing exactly what Excalibur and Arkin had wanted them to do: investigate, assess, lend credibility, so that when a third-party funder is standing behind a case, it is an indication to the court and the other side that this is a strong case as opposed to a speculative investment. These type of merit-driven models do exist, and I think bodes well for the future, because one of the things that we're starting to see, more advanced in some jurisdictions than in others, are what I'm calling the kind of the law firm funder hybrid. Now, in certain jurisdictions like the United States, it's not necessary because they can take wide speculative stakes in the outcomes of their claims without any conflicts in respect of their bar rules. But in most jurisdictions, law firms are limited to the extent that they can actually take a vested stake in the outcome of a claim. And as a consequence, what you're starting to see are these relationships develop between law firms and funders, where they end up operating in a more kind of merits-driven approach, which is being led by law firms, where the financing arm is effectively coming from a litigation financer. So looking forward, and I believe there are certain kind of announcements to this effect already. Various law firms are announcing they've got facilities with various funders and the like. It's an early stage process. But it is not inconceivable to think that there will be law firms who are launched with a litigation and a dedicated litigation financing arm, which would make them arguably more competitive to their American peers and be able to kind of more aggressively pursue those cases. So there you go. That is my view of where we've come from, where we have got to, and possibly where we might wind up.
Thank you so much. Thank you, Ian. I would like to add that Australia actually has introduced the licensing requirement, the AFSL requirement. Probably you're aware of this. So it's a bit ahead of the game, Australia. I don't know if that's gonna make them. They did. So let's take some questions. I see that we have a question to Lewis from Philip. So it says, in terms of future development of third-party funding, do you see much of a role for retail investing and litigation crowdfunding?
Yes, it's going to happen because it's happening now, and you know, I mean, litigation is an interesting subject to actually be investing in. If you're a retail investor, I think it's dangerous because it probably plays a little bit to what Ian was talking about, which is you've got to know how much diligence has actually gone into that particular claim before it's put up there for non-sophisticated investors to actually come and get involved in. Don't get me wrong here. I think it may play a big part in claims that are more like the ESG or something like that. You know, people getting involved and supporting very worthwhile causes, and those causes deserve the right to be heard. And even though they may not be the most commercial claims, but they still deserve the right to be heard. But I just think the danger, I was very interested in what Ian was saying in relation to about pricing risk and also pricing the merits. And I think that's the way our business is developed. We know what we need to receive as a return based on what our success rate is. And we do an enormous amount of diligence. It's painstaking what you have to do. And that's what investors are backing us for, you know, because we have the infrastructure to be able to conduct that diligence. And I would wonder whether some claims that might get put up on a platform for you know, financing like that I'm just wondering whether the people who are putting the cash in are not overly exposed, because at the end of the day, you know, we have a responsibility to, one, people that you give the money to, but you also got a responsibility to your investors to say that you're actually doing everything. But that said, I don't think it's going to stop it. I think there will be more of that because it's just the way we live our lives now. You know, we click and push and invest and buy and like and dislike, etc. So
I would probably add one small thing to that. I've agreed with everything that Lewis just said. With that reference to kind of those risk pricers, as it were, the ones who kind of skip on the due diligence and like to kind of spread bet and all of those other things, they came up the first time, I would say, in and around that 2015 period, and none of them, I believe, are here to this day. And so although we've got an influx of new players now, the extent to those who have kind of come and trying to adopt certain finance strategies for this risk pricing and spread betting, I suspect they will have a go. They will burn out, they will disappear afterwards. But the problem for people like Lewis and myself, who have been here a while and want to be here for a long time, is that it does tend to, or at least risks the provocation of what I would say is quote unquote negative regulation.
Yeah, thank you so much. Thank you, Lewis and Ian. So I do have a question about the development of third-party funding with the new mechanisms and the new ways of funding, especially for consumers. Do you think that it's going to be? Do you think that artificial intelligence probably will be used in funding to make it more accessible for all? Like we see some examples in Germany and Netherlands, through and here in the UK through these apps that provide funding, a way of funding for compensation of delayed flights and such things. Do you see this happening in the future, or becoming a trend probably?
It's an interesting one, because there is a lot of people have espoused the use of AI, and they've gone back into databases and they can tell you which judges, if he's sitting on this particular case, what's his tendencies been, etc. But I think that it hasn't delivered the holy grail which it was meant to deliver, which they certainly promote to funders, which is we can find your cases and make your diligence costs that much cheaper. And I think it's because litigation has got to be one of the most bespoke types of investment that you will ever make, because it's so nuanced. It is so it can turn on a tiny point, and how you actually use AI to determine those points. So perhaps it can work in some types of litigation, very bog standard, very easy type of litigation. And we have some experience in this because we've been involved in providing consumer litigation. So litigation, our litigation funding can either be very large cases. You know, we've funded £18 million for a single case. And then we've got other cases where we put out £2,400 on a per case basis. And you can have a menu almost of things you need to be able to tick, because there's enough data points that you can look and say, if I do A, B, C, D, E, and F, then I know I'm going to have a 92% chance of winning this case. So they're two different things. But I haven't seen the rewards that come from AI delivered yet. Not to say it won't happen, but I haven't seen it yet.
Yeah, we get approached, as I think most litigation financiers do, from various entities, mostly Silicon Valley, where they've developed or they claim to have developed the latest thing when it comes to litigation financing. Now, they have a particularly American bent for that purposes, and their data is almost certainly mostly American, but they're clearly planning on making expansions, and with kind of rules that are coming out of various arbitral institutions right now, where awards will not be, as a matter of course, kept confidential, that they will be published. And of course, as we know with investment treaty cases, those are published already. There is a huge data set to be assessed and dissected, and for algorithms to make havoc with. And I say make havoc because what we're really talking about, and the difficulty I think that AI is still overcoming, is that difference between quantitative analysis and qualitative analysis. Quantitative analysis will tell you only so much. It will tell you how many times a judge has ruled on a particular issue. It will tell you how many times that he may have come down on a binary issue in one side or another. Now, even if it was, 5 times out of 6, he made a particular decision in respect of a particular issue, it doesn't tell you the qualitative data, which you can only get from reading the judgments and possibly reading the pleadings. And that's where AI is still kind of lagging behind. And it's still where, you need good legal analysis and research in order to even make a vague assessment as to whether or not there is a predilection for a particular issue to be decided a particular way. And that doesn't take anything away from the fact that, as Lewis just said, the litigation is an incredibly bespoke asset class.
It makes sense. That's sensible. We still have some questions, but we're running out of time. So that brings us to the end of this lecture. So thank you so much, Ian and Lewis, for your wonderful presentations. But I really myself enjoyed it, and I'm sure our attendees as well did. So thank you so much for joining us again today. And thank you everyone for joining us. And please follow the Cambridge Arbitration Societies on all our social media platforms. We do have a few events coming up, and we hope to see you again.
Great. Abraham, because of those questions that have been asked, some of them are particularly interesting. If you want to shoot them across to Lewis and I afterwards, we'd be happy to provide you with answers, I'm sure.
Sure, yes, certainly. I'll send them to you and over email, and probably we'll send an email to them. Thank you so much, everyone.
Thank you very much,
Thank
Abraham.
you all.
Thank you.
Take care.
Take
See you
care,
later,
guys. Bye. See
Bye-bye.
you, Lewis.